Friends, welcome to today's video. National Register of Indian Citizens. The name NRC evokes volatile emotions and responses in our country. Repeatedly during election rallies, Home Minister has sought to up the ante by mentioning NRC and emphasizing that all the illegal immigrants shall be driven out. There have been mass protests, rallies, sit-ins against the proposed NRC by a large section of population, particularly the Muslims. Not only against NRC but against CAA as well. The issue is not that the illegal immigrants would be driven out, but the troubling insinuations during election rallies and for political motives and the implications of the proposed measures for the citizens. Today, we'll be discussing only the NRC, not the CAA, and its legality and constitutionality. But before we move forward, let's see why citizenship is such an emotive issue. Though the meaning and scope of citizenship has been undergoing a constant change, one thing has remained immutable: that citizenship is the fountainhead from which several basic rights like right to freedom of speech and expression, minority rights, voting rights, etc. flow. These rights are generally not provided to non-citizens anywhere in the world, barring few exceptions like Spain, Argentina, etc., where there is conditional equality. But in general, citizenship confers rights and privileges on citizens which are superior to those provided to non-citizens. Still worse is the condition of those who are treated as illegal immigrants, with some enduring inhumane treatment in detention camp. If you ask such unfortunate people like Romas, Kurds, Rohingyas, they would bear witness to the fact that persons shorn of citizenship lose the very right to humane treatment. Therefore, any measure that impacts citizenship must meet the rigorous standards of due process of law and must be carried out with utmost conscientiousness. More so in a country where citizens are sovereign, like our country. What is NRC under the citizenship law of the country? In India, the provisions with regard to citizenship is solely governed by Part 2 of the Constitution of India and the Citizenship Act 1955. In 2003, Citizenship Act 1955 was amended and Section 14A was instituted. It provided for compulsory registration of citizens of India and provision of national identity cards to them. To fulfill the mandate of the section, the Citizenship, Registration of Citizens and Issue of National Identity Card Rules 2003 were framed to provide for the method and the procedure for preparation of National Register of Indian Citizens and for resolution of disputes arising in the process. These rules provided exclusively for the preparation of NRIC, or what is commonly known as NRC, and not for criteria, conditions or the procedure for determination, acquisition or termination of the citizenship, for which the relevant conditions and the requirements of the Citizenship Act 1955 has to be fulfilled. And yet these NRC related provisions go beyond its mandate and against the provision in the Parent Act and says that the doubtful citizen shall be referred by the district magistrate to Foreigners Tribunal through an entirely different provision in Foreigner Tribunal Order 1964 and under an entirely different Foreigners Act 1946. So these rules cannot legitimately deprive a citizen of citizenship under the law of the country. Let's delve a bit deeper. the provisions with regard to termination of citizenship in the Citizenship Act 1955 is provided for in sections 8 to 10 of the Act. To remember, this is very important. Section 8 deals with the cases where a citizen renounces his citizenship. Section 9 deals with those cases where a citizen acquires the citizenship of another country. And Section 10 deals with those citizens who have acquired the certificate of registration or naturalization by fraud, misrepresentation, concealment of material fact, or have been disloyal to the Constitution of India and engaged with the enemy during the war and otherwise. So, Section 10 anyways does not apply to those citizens who are so by birth or descent. And Section 8 is a provision with regard to those persons who have renounced their citizenship. So, legitimately, a citizen who is so by descent or birth, that is the native of this country, can be deprived of his citizenship only under Section 9 when he acquires the citizenship of another country. Now, the NRC related Citizenship Rules 2003 has been formulated to fulfill the mandate of Section 14A, and if it has to go beyond and has effect in the nature of deprivation of citizenship, then it has to fulfill the requirements under Section 8 to 10 of the Citizenship Act 1955. And we have seen that the only manner in which a citizen who is so by birth or descent, that is the native of this country, can be deprived of citizenship is when he acquires the citizenship of another country. Since the NRC does not deal with only those people who have acquired the citizenship of another country, but with the whole population of the country, it goes beyond the mandate of the Citizenship Act 1955 and is therefore void and illegal. There's another major infirmity with the Citizenship Rules 2003. These rules came into effect on 10 December 2003, and yet it potentially affects the citizenship of those individuals who were born before that date. Now, it is well established principle of law that a vested right, a right that is inalienable to a person, cannot be taken away by an executive rule or order. So, how does the government seek to declare those who do not find their names in NRC as foreigners? Paragraph 8 of Schedule to Citizenship Rules 2003 says that a person who does not find his or her name in NRC or other aggrieved person, aggrieved by the decision of the registering authority under NRC, can appeal to Foreigners Tribunal. And a concomitant provision is inserted in Foreigner Tribunal Order 1964 in the form of Section 2, Subclause 1B. In case no individual appeals, the district magistrate can refer the doubtful cases to Foreigners Tribunal under Section 3A, Subclause 6 for the opinion of the tribunal whether such a person is foreigner or not within the meaning of Foreigners Act 1946. So, in essence, the procedure that is applied to the doubtful citizens is as if those individuals are foreigners, and by implication, Foreigners Act 1946 is applied to such individuals. So, the core of the problem is this presumption that the persons who do not find their names in NRC are foreigners. And for finding one's name in NRC, an individual would need to present one of the documents out of a given list. In the case of Assam, where the NRC process is complete, the list comprised 14 valid documents of pre-1971 date. In case individuals possessed document of date after 1971, one such document along with one of the 8 documents from a given list of the person's parents which could establish a pre-1971 connection was required. So effectively, NRC related provision require possession of a document as a condition of citizenship. So here is the big question. Is there any law in India that requires a citizen to possess certain documents or to register oneself as a citizen as a condition or proof of citizenship? There exists no such law under the citizenship law of the country. A law that comes close in functionality, which could have had performed such a function of proof of citizenship, is the Registration of Births and Deaths Act 1969. But this law neither purports to establish citizenship expressly, nor it can be assumed by necessary implication to perform such a function, since it caters to several other policy-making requirements of the Government of India. Had there been no other purpose or function, there could have been a weak argument that what was the purpose? Furthermore, the fact that the violation of this act carries a maximum fine of rupees 50 and not the deprivation of citizenship clearly indicates that the intention was not for the act to serve as a proof of citizenship. By its very nature, this act cannot put the burden of registering on the individual concerned, because a newly born person or a already dead person cannot register himself. So, such person cannot be penalized for not registering. Another law that comes close in functionality is the Aadhaar Act, providing us the Aadhaar card. But this law expressly disassociates itself as being a proof of citizenship, as all of you can find written on your card. Hence, the use of any list to determine the citizenship of the entire population based on whether the persons possessed certain documents or not would contravene both the Citizenship Act as well as the Constitution of India, and thus would be both illegal as well as unconstitutional. This would be so even if the list was purported to be prepared under the Foreigners Act 1946, because in substance it would determine the citizenship only. This was legality. But let's look into practicality of the requirement of producing such documents, which of course would not correct the manifest illegality and infirmity of the NRC provisions. Is the state not right in contending that not being able to produce just one out of over 14 or 15 documents that may be permitted to get enrolled in the NRC is sufficient to show prima facie that an individual is a foreigner? In my opinion, it is not. Every person may have her own peculiar circumstances and reasons for not having documents, or their documents may carry errors. The ground reality clearly presents a situation where it's entirely conceivable that a large, substantial proportion of the population may not have any document. According to National Sample Survey Office, nearly 500 million individuals in India are landless. Nearly 17 million are homeless. Will they have land or house documents? Nearly 12% of India's territory is prone to flood. So missing documents are not inconceivable. Nearly 15% of the population is illiterate, and it's high as we go back. So where will they get the education certificate from? Even overall, several million people will be left in a limbo. Besides, the practical experience has shown that spelling mistakes, variation in title, etc. is common in our country due to historically low literacy. So even the practicality argument fails. And the people already reeling under floods, reeling in illiteracy, poverty, etc., which is partly due to the failure of the government functioning, must not be whipped doubly by requiring them to produce documents as a proof of citizenship which they may not have, and hence there's a scrupulous requirement to conform to the law of the land with regard to the citizenship. Over and above that, the functioning of the Foreigners Tribunal has left much to be desired. Amnesty International has reported arbitrary procedures, unreasoned orders, executive interference, going so far as that there has been instances of those judges retaining jobs who report higher number of individuals as foreigners, and all this has caused havoc in the state of Assam and must not be replicated for the purpose of the whole country. There is another major problem with the Foreigners Act. It reverses the burden of proof. In normal criminal procedure, say when a person commits theft which carries a maximum imprisonment of 3 years, it is the government that has to prove the allegation beyond reasonable doubt. But under the Foreigners Act, it is the foreigner who has to prove that he is not a foreigner. This is a violation of due process requirement under Article 21 of the Constitution of India. In case where it's applied to the citizens, it not only affects this particular fundamental right of the citizen, but impacts, has effect on several other of his fundamental rights. I'm using the term effect because since 1970 R.C. Cooper judgment, that is the bank nationalization case, and certainly from 1973 Bennett Coleman versus Union of India judgment, it is the inevitable and direct effect or consequence of the government action or law on the rights of the citizen, which determines whether such government action violates fundamental rights and is constitutional or not. The inhumane conditions existing in the detention camp makes the whole scenario still more grossly unconstitutional. There is one slight protection for the foreigners under the Foreigners Act 1946 and the subsequent Foreigners Tribunal Order 1964. When the government refers the question as to whether a person is a foreigner or is not to the Foreigners Tribunal, it has to satisfy the tribunal that there is a sufficient case to proceed forth, after which the burden of proof shifts to the alleged foreigner. So, when the Foreigners Tribunal, after being satisfied, issues notice to the alleged foreigner, giving him the opportunity of fair hearing, it is the foreigner who has to prove that he is not a foreigner. In case of NRC, even this protection has been snatched from those individuals who are not included in the NRC list, as non-inclusion in NRC has resulted in the Foreigners Tribunal issuing blanket notices to such individuals. So basically, the executive satisfaction in the NRC has replaced the judicial satisfaction of the foreigners tribunal. How did this misapplication happen? In case of Assam, due to large-scale illegal immigration during 1971 war and before that, protests against such illegal immigration and the deteriorating law and order condition forced the government to apply Foreigners Act to determine the bona fide citizens of the state of Assam. But the subsequent arbitrary functioning of the Foreigners Tribunal caused severe hardship to the bona fide citizens. The government then passed a state-specific, that is Assam-specific, Illegal Migrants Determination by Tribunal Act 1983, which put the burden of proving that a person is a foreigner back on the state. This act was challenged in Sarbananda Sonowal versus Union of India before the Supreme Court of India, and the Supreme Court struck this act down as violative of Article 14 of the Constitution of India, because it said that this act was an act separate from what was applicable in the rest of the country. In the rest of the country, Foreigners Act, which put the burden of proof on the alleged foreigner, was there. This judgment suffers from one major legal infirmity, which happened because no petitioner pressed the point that Foreigners Act was intended to be applied in cases where there was reasonable apprehension of a person or a group of persons being foreigner. Foreigners Act was to be applied in specific cases of reasonable apprehension and not to the entirety of the population of an area or a state, as it would in effect, in substance, determine the citizenship of the natives of the whole region, of the citizens who are so by descent or birth, beyond what is envisaged in the Citizenship Act and the Constitution of India, as we have already seen. So such application would be both illegal and unconstitutional. See, there was some justification for application of Foreigners Act in the state of Assam due to the peculiar circumstances existing there, as we have already seen. Though per se, this application was illegal, as already explained. It was the fault of the government not to register the illegal immigrants during even the war, and for that fault, the bona fide citizens of the state could not be deprived of their legal and the constitutional rights. So given at best the irregular application of Foreigners Act in the state of Assam, a separate law providing for the putting back the burden of proving that a person is a foreigner on the state was very much required, because the general population of the state comprised the bona fide citizens, the prima facie citizens invested with several legal and constitutional rights, and not that of the suspected foreigners. But since this point was not pressed, we have the judgment that we have in the case of Assam. Now, no such justification as exists in Assam exists for the rest of India, and yet this very misapplication, this very unconstitutional application of the Foreigners Act on the prima facie citizens is sought to be extended to the rest of the country in a manner that is grossly unconstitutional. Let's delve a bit deeper. What is the basis of this inversion of proof? From where do we get this principle? The underlying principle of this doctrine of inversion of proof, as also found in section 106 of the Evidence Act, is that the specific fact required to establish a particular claim or right lies within the specific knowledge of the person making such claim or is taking such a right. This principle is based on the practicality and not on justice. In modern law, its origin can be found in insurance law, since it is the interested person in whose specific knowledge the facts with regard to the insured person or things lie. Even otherwise, there is a greater mix of practicality in commercial law as compared to other branches of law. This must not be applied to the citizenship law, where a bundle of rights, including several fundamental rights and not just commercial rights, is at stake. This would be in gross violation of the due process of law and various other constitutional norms. So, this Foreigners Act 1946, which is a pre-constitutional era act, is a flawed act and has not been brought in consonance with the Constitution of India. To apply it to the citizens of a country where there is popular sovereignty, where the citizens themselves are the source of all power, is grossly unconstitutional. Here I must clarify and emphasize that I am not arguing that a sovereign state cannot exclude or expel foreigners, which it very much can, but that the determination of citizenship or the foreigner status must be under a substantive law that guarantees due process of law. In fact, due to the trauma and hardships associated with the statelessness, the citizenship law is undergoing sea change globally. Several countries like Germany, Switzerland, Mexico not only follow the due process of law, but also guarantee that in case a person, when declared foreigner, is to become a stateless, such person must never be declared foreigner and must be considered citizen of these states. Now, the least we can do is to follow the due process of law as instituted in the Constitution of India, which is a sacred document for us. So, what is the solution to this problem? Can we not prepare a list of our citizens? Should we allow illegal immigration if it is to happen? We must not. And we can prepare a list of our citizens. But while we do so, we must remember that India has a constitution that espouses popular sovereignty. Citizens hold a sacrosanct status as the sovereigns of the country and not as subjects, as used to happen during the colonial rule, to which era belongs the Foreigners Act. Citizens are invested with a set of inalienable rights which must not be trifled with. So any attempt to prepare a list of our citizens must be preceded by a law that specifically requires the possession of certain documents or registration with certain authorities as a proof of the citizenship. Such law must be published widely, effected prospectively, and adequate time should be provided to citizens to comply with it. And given the situation of corruption in our country, the sanction for non-compliance, I'm not talking about the burden of proof, which must lie with the state according to due process doctrine, but the sanctions, which generally happens in the form of fines, must be imposed both on the citizens as well as the authorities, so that citizens do not suffer because of the abuse of power by the authorities. That's it for today. Thank you for watching this video. Please subscribe.